Mistake. A mistake is said to have occurred where the parties intending to do one thing by error do something else. இதை பண்ணுறதுக்கு பதிலா அதை பண்ணினா mistake. Mistake is an erroneous belief concerning something. இதை பற்றியோ தப்பான நம்பிக்கை. Mistake of law or mistake of fact. ரெண்டு types. There are two types. Mistake of law and mistake of fact. Mistake of law means what? Some mistake according to law. Mistake of fact means the truth is wrong. Right? Type of mistake of law. Mistake of Indian law. There can be two mistakes, right? According to foreign law and according to Indian law. The contract is not voidable because everyone is supposed to know the law of this land, law of his country. So not voidable. If he makes a mistake according to their own country's law, it's not voidable. But if you are making a mistake according to a foreign law, it can be a mistake of fact. Contract is void. If both the parties are under a mistake, as to a foreign law, because one cannot be expected to know all other countries' laws. Mistake of fact. Both the parties to take an agreement are under a mistake. If there is a mistake of fact occurring, bilateral. If two parties are under mistakes, then it's called bilateral. Only one person is a mistake, doing a mistake, it's a unilateral mistake. Bilateral mistake is defined under section 20, where both the parties to an agreement are under a mistake as to the matter of fact essential to the agreement is void. Where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement, both are under mistake, the contract is void. Three conditions are to be satisfied to declare something as a void. One is, both the parties must be under a mistake. Very clear, bilateral. Mistake must be of fact and not law. If it is law, then it cannot be voidable. An erroneous opinion of the value of thing which forms the subject matter of agreement is not deemed to be a mistake of fact. X buys a painting believing it to be worth 50,000, while in fact is worth only 5,000. The contract is not void. You are believing something. Nobody told you. You are believing. So, it's not a mistake. It cannot be voidable. Mistake must be relating to an essential fact. A agrees to sell B a specific cargo of goods supposed to be on its way from England to Mumbai. It turns out that before the date of the bargain, ship conveying the cargo has been cast away and the goods lost. Neither party was aware of the facts. The bilateral, the essential fact, right? Ship coming is a very important fact. Agreement is void. A agrees to buy from B a certain horse, Kudurai. It turns out that horse was dead before these people were. Neither party was not aware, was aware of the fact the horse is dead. So void. A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of the agreement, but if both the parties are ignorant of the fact, agreement is void. Means what? Somebody was given an estate till the other person's life is there, B's life. But what happened? A is selling it to C, while P is dead. The original contract, the original idea is when B is dead, then the entitlement is gone. There is no estate now. So, not possible. Why? So, if the bilateral mistake is to the subject matter, we all know what is subject matter. So, there are many things. Existence of the subject matter. We saw that, right? Horse is there, horse is not there. People are there, people are not there. Quantity, 100, 200. Quality, basmati rice, ordinary rice. Price, 50,000, 5,000. Identity. There are two cars. I thought this, I thought that. Title. I myself not owner. So there are many things. Subject matter itself, there is a mistake. A agrees to buy from B a certain horse. Turns out that horse is dead at the time of bargain. Neither party was aware. Agreement is void because there is a bilateral mistake as to the existence of the subject matter. Subject matter itself is not there. A agrees to buy from B all his horses, believing that B has two horses, but actually has three horses. This is the identity problem. It's a quantity problem. Sorry, the quantity of the. I am thinking two. You are having three, so quantity problem. A agrees to buy a particular horse from B. Both believe that to be a racehorse. Turns out to be a cart horse. It's a quality. A agrees to buy a particular horse from B who mentioned in his letter the price was 1150 instead of 5150. Mistake of price. A agrees to buy from B a certain horse. B has only one race horse and cart horse. A thinks that he is buying the race horse, but B thinks that he is selling the cart horse. Agreement is void because there is a bilateral mistake as to the identity of the subject matter. Example 6. A agrees to buy a particular horse from B. That horse is owned by A. Right? Because the title is a problem. Possibility of performance. Agreement is void where there is a bilateral mistake as to the possibility of performance. In other words, where the parties to an agreement believe that the agreement is capable of performance, while in fact it is not so, the agreement is treated as a void. The impossibility may either be physical or legal. The agreement is void where there is a bilateral mistake as to the possibility of performance. Where the parties to an agreement believe agreement is capable of performance, while in fact it is not so. Agreement is treated as void. Could not be done. There is a problem. Maybe impossibility can be physical impossibility, or maybe because of legal problem, legal impossibility. Both are. We thought it can be done, could not be done. So it's a bilateral mistake. Unilateral, one side, means where only one party to the agreement is under a mistake. According to section 22, a contract is not voidable merely because it was caused by one of the parties to it being under mistake as to the matter of fact. So only one person. X sold votes to Y by sample, thinking that they were old votes, purchased them. In fact, the votes were new. You know, right? Old rice and all we buy. Old rice is expensive. Maybe similarly, old oats, old wheat, all expensive. Oats was new. It was held that Y was bound by the contract. So there is a sample, right? The agreement is void where unilateral mistake. Y was thinking, right? Y was thinking it is old, but it was new. So thinking is only one side mistake because there was a sample given, right? But this unilateral mistake, there is a small exception there. If it is relating to the identity the person contracted with, suppose instead of contracting to A, if you are contracting B wrongly, even though it is a unilateral mistake, that is void. One Blancon is a person, knowing that Blancon and Company was a reputed customer of Lindsay and Company, placed an order with Lindsay and Company by imitating the signatures of Blancon. The goods were then sold to Kandi and innocent buyer. A suit was filed by Lindsay and Company against Kandi for recovery of goods. Now what happened? There is no contract between Lindsay and Company and Blancon, as Lindsay and Company never intended to contract with Blancon. As such, Kandi didn't get a good title, hence he must return the goods or make a payment for goods. So what happens? Blancon is one person. Blancon and company is another company, another customer for Lindsay and company. So Blancon placed an order with Lindsay and company by like ordering on behalf of Blancon and company, he ordered a good. Then why he sold that to Kandi, innocent buyer. So Lindsay and company understood his fellow had a cheating. So now it was held that there is no contract between Lindsay and company and Blancon. As Lindsay and company never intended to contract with Blancon. He was intending to contract only with Blancon and company. So Kandi never got a title. A agrees to buy from B a certain horse. B has only one race horse and cart horse. A thinks that he is buying the race horse, but B thinks that he is selling the cart horse. Agreement is void because there is a bilateral mistake as to the identity of the subject matter. Example 6. A agrees to buy a particular horse from B. That horse is owned by A. Right? Because the title is a problem. Yes, know that on account of the criticism of the plays in the past, you would not be allowed entry into the performance of the play at the theatre. The managing director of the theatre gave instruction ticket should not be sold to Yes. Yes, however, obtained ticket through one of his friends. On being refused admission to the theatre, he sued the damages for breach of contract. It was held that there is no contract between theatre company and Yes, as the theatre company never intended to contract with Yes. An old illiterate man was induced to sign a bill of exchange by means of a false representation that it was a guarantee. This is an identity, right? Never intended to sign a bill of exchange. Wrong. Contract shall be valid in binding in spite of the mistake as to the identity of party in all those cases where the parties are willing to enter into contract with any person. Thus, if mistakes are related to the attributes and motives of the person, such as creditworthiness, it will not make the contract void. It may at the most make it voidable for fraud. Philipson versus Brooks case. One Mr. North entered a jeweler shop, selected a ring, which the jeweler agreed to sell against the payment by check, which North signed in the name of Sir GB, a man of credit and standing. North pledged the ring with Brooks. In the meanwhile, check got dishonored. It was held that contract between North and jeweler was valid, as the jeweler agreed to sell goods to the very person who entered the shop. Thus, the contract had been made before the goods were delivered to North. As the contract was induced by fraud, jeweler could rescind the contract. However, pledge made by North was valid. The jeweler's right was only confined to filing a suit against North to recover the damages. There are two parts here. Right? One person who entered the shop, he gave a check on behalf of somebody for he was doing a forgery, right? And got the ring and pledged with somebody else called Brooks. Now the check, what the forged check was, dishonored. It came back. Now North was the man who entered the shop. So jeweler agreed to sell to North. So the contract is valid. The person GB, the good man, did not come into picture at all. So contract is there between North and the jeweler. And also this pledging contract between North and the jeweler also there, right? So now there are two contracts. So this jeweler has got only damage is claimed. So what are the effects of mistake? One is, in case of bilateral mistake, as it's essential fact, agreement is void. In case of unilateral mistake, identity of person, agreement is void. Nature of contract, unilateral mistake, agreement is void. Any other matter, agreement is not void. Obligation of agreed party, what best they can do. He must restore any benefit received by him under the contract to the other party from whose benefit was received. Section 64. Restitution. Obligation of other party. Person to whom money has been paid or anything delivered by mistake must repay or return it.